Now, we are waiting for what Toronto police have described as a significant development today. And with that, we've invited to studio right now Karen McArthur. She's a criminal defense lawyer in Toronto. She joins us right now. Karen, thank you for joining me today.
Good morning, Michael.
I want to begin with what we heard from Toronto police. This idea that this is a significant development that we're watching for today. What do you make of that?
Well, I anticipate we may be seeing guilty pleas today.
And because at this point, Bruce McArthur has not entered any plea.
He hasn't entered any pleas, no. Several months ago, he waived the prelim to go directly upstairs to 361, which is the Superior Court. There have been a series of meetings, to my understanding, between the defense, the Crown Attorney, and Justice John McMahon, who is well known in the courts for bringing matters to the appropriate resolution, or guilty pleas, which I think we're going to see today.
Mm-hmm. Let's go back, though. As you said, he waived his right to a preliminary hearing. Explain to people at home why that's significant.
A preliminary inquiry allows a defendant to test the evidence. It's a significant procedural step that most often is exercised if you plan on proceeding to trial. So the waiver of the preliminary inquiry was an important hallmark along the way, a message, as it were, to those in the know that potentially this might wrap up in a guilty plea. He is, after all, facing 8 counts of first-degree murder.
Mm-hmm. And talk to us about the penalty for that. What might he serve if he does enter a guilty plea, if the court accepts it? What type of sentence might he be looking at here?
So the automatic sentence for a first-degree murder conviction is 25 years. It's life with no eligibility for parole for 25 years. And then with multiple first-degree murder counts, he could be serving consecutive sentences with virtually no potential for parole. Arguably, they are bringing this to conclusion so that he might have some prospect of parole.
Explain that.
If he were to live for a further 25 years and somehow a deal had been engineered so that if he did plead guilty to all 8 counts or some of those counts in exchange for being eligible for parole at 25 years. Mm-hmm. That's potentially what has been going on behind the scenes. I don't know, I'm not on the inside track. I'm just looking at the clues that are out there and trying to educate the viewer. So we'll know more very soon. I believe the court is supposed to kick off momentarily, 9:30. We'll have to wait and see what time Bruce McArthur arrives at the courthouse.
Yeah, and let's pick up on that point, because we do know that there are people inside the courthouse right now, family of victims. We know that the owners of the Mallory Crescent home, the central site of the investigation, are also in that courthouse. But at this point, we can tell you that Bruce McArthur is not yet in the courthouse. The court has just opened, but there are other matters on the docket before the McArthur case comes up. But that said, you know, you talk about the sentencing here and the fact that it could be consecutive, or there might be some room for a parole down the road. So even if he does, and this is a big if right now because we don't know for certain whether or not he's going to enter a guilty plea when he walks into that courtroom, but if he does enter a guilty plea, walk us through the process. What happens afterwards?
So what will happen if and when he arrives today? There's quite a significant snowstorm, and generally inmates are housed far away, so he may arrive late. But when he does arrive, he'll be brought in with the court guards. There'll be a bit of back and forth once again between the defense and the Crown, an acknowledgement from Justice McMahon that Bruce McArthur, the defendant, is there, and then they will start into, if in fact there is going to be a guilty plea, the judge will inquire of Mr. McArthur, Bruce McArthur, the defendant, whether or not what is about to proceed is done of his own free will and volition. Nobody's pressuring him to enter a plea. It's an inquiry that the judge is obliged to make, and Justice McMahon does it very well. Assuming that goes according to plan, that Bruce McArthur says he's doing it of his own free will, he's not being forced into this, he understands what he's doing, he understands that he's waiving his right to have a trial. Then, after that is concluded, they arraign him on the counts in the indictment that he's chosen to plead guilty to, and he will say guilty or not guilty. After that arraignment is taken, the Crown Attorney then reads in the statement of facts. In the normal course, when you're doing negotiated pleas, the statement of facts has been agreed to in advance. It's been hammered out. A lot of work goes into narrowing down, specifying the facts upon which the defendant will plead. And so we don't know if he'll be pleading to all 8 or just some of them, or what he might be saying by way of contributing factors, as it were.
And this all ahead of any sentencing hearing afterwards?
This is all ahead of any sentencing hearing afterwards.
So how long of a process are we still looking at here? And again, presupposing that he is going to enter a guilty plea here.
Probably this morning. It will be concluded this morning. Then, in addition, the victims and the people that have been affected by this have their opportunity to be included in the process and to have their say. That may take more time, but the actual arraignment and reading in of the agreed statement of facts should be concluded this morning. Given the number of victims involved and the number of people affected by this, I'm not sure if it will be completed today or may take an additional day.
If he had not actually waived his right to a preliminary inquiry, as you say, how much more time would have been added to this whole process?
If he had not waived his right to a preliminary inquiry, I expect that a preliminary hearing of this magnitude involving 8 separate homicides would have taken at a minimum 2 months of valuable court time, potentially even 3 months, going through the forensic evidence and all of the proof. Because at a preliminary inquiry, the Crown is obliged to prove each of the essential elements of each count against a defendant. The time, the place, the who, and most importantly in homicides, the why, the motive part.
The motive part, as you say. Well, listen, Karen, I'm going to ask you to stay here with us. Don't leave quite yet, as we are at this point, again, waiting for Bruce McArthur to arrive.